that it was very difficult for me.
So we'll
my Lord.
see.
My suggestion was, if I may say, my Lord, whatever I could say, my Lord, after me with Dr. Singhvi, because he was.
But I
And
would
then Lord
request for
Vishwanathan.
all, my lord, to kindly give everyone some time. That's all.
Then Vishwanathan.
No.
But no repetition now. After the main arguments are done by the first 2 or 3 council, I think that will be.
So I thought,
We won't
I
repeat.
thought, my Lord,
There is only one
cover a
point.
large portion.
You came with different petitions, came
Now
with
there's
different
one point.
scopes, came with different areas. One point, which is what we've told the other side. One point we've told you.
True.
Therefore, we will not permit you to go here and there. Certainly not.
We won't repeat.
Anand, having had the benefit of yesterday's deliberations, my lord, my note is confined to your lordship's queries yesterday, plus the objections in the counter and the additional counter by them, and a bit of international jurisprudence, my lord, and
Fair
here in
enough.
a written note.
Whatever jurisprudence
Lord,
you'll
you
do.
may at the appropriate time call
Sir,
upon
and
me, my lord.
you can tender it in writing. We'll read it.
We will tender it in writing, but we won't repeat anything, my lord.
All right,
All
fair
I'm saying is,
Transgender right,
Yes, I-
15 minutes.
Fair enough. That's all right. We're not the sorts who will say that, look, now we're going to close shop and please go away.
On the
Your
lighter
lordship
side,
never does in any way.
lighter side, the chief is far more liberal.
I'm sorry, my lord.
Chief is, I can see chief is far more liberal in giving time. than
Yes,
me.
yes. Lordship never shut out.
Therefore, I'm trying to assist the Chief Justice in this bench. And one of this is everybody will adhere to very limited period of time and stick to the point. Period.
Point and not repeating. And not repeating.
And
Yeah.
with
not
the prior
repeating.
written note.
Lord,
All
only
right,
one
let's
thing,
get
my lord.
started.
Before my
The
lord, the
prior
petition,
written note.
Lord, before the petitioner starts,
It's an outline, my lord.
Lord, there is something which I need to place on record, my lord.
Okay.
Your lordships need not read. I have given the copies yesterday to the other side.
What is it?
What it is, my lord, in continuation of my request that states be heard. Lord, page 5, directly your lordships may come. The Union of India has written letters to all chief secretaries that this is a matter, my lord, may I read that only?
So now you have told them that this matter is going on.
Yeah.
Matter is going on. There are
That's excellent. So that now, it's not that the states are unaware. You have informed them that if somebody has to
Lord,
say something, they'll.
that would not, my lord, dilute my request that states should be issued notices. That's all. I'm, my lord, making it clear. That's
So let me deal with that argument first before I go forward.
No, not at all, please. We have a council on our legs. Please, no, not at all. Yes, Mr. Rodgi, no.
Yes, Milord, I just want to deal with this argument of the state business. Milord, I am challenging, Milord, a central law. Merely because, Milord, it happens to be in the concurrent list, there is no rationale to say, Milord, that this petition will be bad for non-joinder of states, Milord, because it happens to be in the concurrent list. Milord, your lordship sees entry 5. As an example, entry 8, Milord, is insolvency. Insolvency was challenged, Milord, in Swiss ribbons in this court. There was no question, Milord, of saying that barely because it happens to be in the concurrent list, but you challenge the central list, therefore the petition won't lie, Milord, unless everybody
You
comes.
need not labor the
It's
point.
absolutely wrong.
Lord, if the state favors
No,
the law.
one second. Milord, absolutely wrong, as the lordship.
You have to
Second,
hear that entity.
whoever wants to
law-
come is welcome
whose
in
law
this
is
court,
valid.
Milord, your lordship
Whoever
won't
wants
say
to
no.
intervene, yes.
He really did not call upon you to even.
And Milord, I only want to comment on one thing. The letter is addressed of yesterday. Your lordship issued notice 5 months ago. I mean, if you had somebody, you could have issued a letter earlier.
All right. Yes, Mr. Rodgi.
Completely unnecessary, Milord, to show
Yes,
all this to the court.
So yesterday we were looking at, we looked at Navtej. We were on para 470.
Yeah. No, Milord, your lordships asked me to show 469.
Yes.
So I'll come back to 469 at page 235 of the report. 469. I had read 468, my lord. I will start with 469. Citizens of a democracy
Just give us,
cannot be compelled to have their lives
give us a moment.
pushed into.
Mr. Rodgi, just one second.
Just give us PDF page
PDF
My lord,
1048.
1048.
PDF will be 1048, my lord. Compilation page is 1017. And the reports page is 235.
Compilation is? Which compilation is this? Volume? Compilation 1.
Compilation 1, my lord.
Compilation 4.
Compiling.
Compilation 4, volume 1.
Four is all the judgments.
Four is foreign judgment.
Foreign judge. Foreign.
Four is foreign
Foreign
judgment.
judgments.
So in that, volume one, has
Volume 1.
volume, all the Puttaswamy, etc.
I was reading from that yesterday, my lord.
No, we just lost track. 104.
Your lordships have,
469.
my lord, does Justice Call have it, my lord? Or?
Yeah.
Little improvements from
My
yesterday.
lord, let me start with respect from 468, my lord. The contextually 468.
We are encouraged by your lordship's efforts, lords.
Mr. Dwivedi, I hope you are also working on your iPad.
Encouraged.
I thought I'll get away.
468.
See if it's persuaded me to do.
I'll try to persuade my lords, my colleagues.
The exercise of the natural and inalienable right to privacy entails allowing an individual the right to a self-determined sexual orientation. Thus, it is imperative to widen the scope of the right to privacy, to incorporate a right to sexual privacy, to protect the rights of sexual minorities. Emanating from the inalienable right to privacy, the right to sexual privacy must be granted, it's important now, the sanctity of a natural right and be protected under the Constitution as fundamental to liberty and as a soulmate of dignity. So my right now, my lord, is cast in stone by first the 9 judges and this. And if I may say so, my lord, in retrospect, I was thinking, in some measure, we are revisiting this issue, though this issue is decided. So, my lord, that's why I said, my lord, when we request a declaration from my lordships, the declaration should not only be a badge, that I wear a badge by saying that the Supreme Court has given me the right to say that I am married. But, my lord, it must at least go forward, even in some limited extent, not, my lord, the entire panoply of all the laws, but at least, my lord, in those laws which are otherwise secular and which do not touch, my lord, personal laws, where that right has to flow and give me something real. I have made a list of 4 or 5 items, my lord, as an example. Take, my lord, Payment of Gratuity Act. Other acts will provide pension. They provide, my lord, only to a spouse where the underlying thing that you are married. I'm going to give you, my lord, some of them. One of them, my lord, is the, hold on. I'll give you, my lord. One of them is judge's pension. A judge's pension will go to a spouse. Now, a spouse presupposes that you have to be married. So, if one of us, my lord, becomes a judge and then he gets a pension, tomorrow an issue will arise whether you are going, who will get the pension? My lord, for example, under the Income Tax Act, a gift is exempt from tax, my lord, as between members of a spouse which predetermines, my lord, a marriage. Now, if you're going to do that, how will that work, my lord? So, there are a large number of acts. So, the secular acts where, my lord, this issue doesn't arise of, my lord, personal laws. So the effect or declaration of marriage must flow to get us real rights where, my lord, these day-to-day things, at least in secular parts, are, my lord, involved. Motor Vehicles Act, Gratuity Act, Pension Act, my lord, Juvenile Justice Act provides for, my lord, adoption. Says you can't adopt. As a living, you can't adopt unless you are married. So all those, my lord, those at least it must flow. Otherwise, what will happen? I'm sorry to use the phrase, I get a declaration, I get a badge. 5 years ago, I got that there'll be no criminalization. After 5 years, I get this badge. Then, my lord, when I go somewhere, again those problems arise. They say, no, Supreme Court hasn't given you anything. Given you a badge of being married, fine. In society, you can go around and say, I am a couple who's married. But what is the real impact on the ground? Therefore, my lord, I have framed one or two reliefs which I'll indicate. I'm only saying, my lord, idea should not be to go on revisiting the same issue from Puttu Swami and Navtej, back and forth. And we should only, at the end, if your lordships give me some, my lord, declarations, as and when in some other issues, something has to be fleshed out, it will come back to court. Nobody can, my lord, think of impossible.
Ring of litigations.
Yes.
Incrementally, as you call it.
Yes.
Lord, rather than going at it whole hog.
Yes.
Whole hog you feel is a problem.
Yes.
Why is it a problem?
No. I am not saying it's a problem.
You don't want, because you don't want to open up the other fronts right now. You feel, what is the reason? You feel it's a distraction?
No, but I'm only saying only personal laws. I'm only saying
The point is, there is an organic hole in this.
yes,
That's one point. Is
yes.
get a declaration, then you say that in some of these, what you term as secular, or
I term them as secular, non-personal.
so far so good.
Yes.
But when it comes to personal law, this will also implicate personal law, isn't it? Because some of your
Some of them will argue, my lord.
Yes.
Menka
now,
wants to argue.
Therefore,
You don't want to. All right.
you may not argue. You have strategic reasons why you will not argue. But this court will have to engage itself once more, twice more, maybe 3 times or 4 times more.
Yes, absolutely right.
Each one of these. The question is then we are not looking at it as a whole. We are looking at it in a truncated manner, which means that we, perforce, for the sake of, let's say, convenience or clarity, we say that we confine this declaration or whatever relief you are seeking to the Special Marriage Act, right? Which means that others who do not wish to or are not aware of this form of marriage, and I use these words very carefully, who are not aware of this form of marriage, of this going through the civil form of marriage, we can't presuppose, we can't assume that everyone knows this. They are denied this, right? Either they choose their religion or whatever. If they choose to, then they are out of this. So that is one aspect.
That is
Second aspect is they intersect with personal law even here. So keep that in mind when you make this.
yes, Malad.
Yes. I'll tell you later. Yes. I appreciate, my lord, for your lordship's comment. So now 469. Citizens of a democracy cannot be compelled to have their lives pushed into obscurity by an oppressive colonial legislation in order to ensure the sexual and gender minorities' fulfillment of their fundamental right. It is imperative to confront the closet and, as the necessary consequence, confront compulsory heterosexuality. Confronting the closet will entail reclaiming markers of all desires, identities, and acts which challenge it. It also entail ensuring that individuals belonging to sexual minorities have the freedom to fully participate in public life, breaking the invisible barrier that heterosexuality imposes upon them. The choice of sexuality is at the core of privacy, but equally our constitutional jurisprudence must recognize that public assertion of identity found in sexual orientation is crucial to the exercise of freedom. But I submit 469 will fully apply, and instead of the words colonial legislation, we can use, Lord, the words colonial mindset. It is that mindset, my lord, which started from then. Society has evolved. Your lordships, my lord, struck down the barrier 5 years ago. But some parts of that mindset remain, which is evident from the stand of the respondents, including that of the states. And this mindset is, my lord, is implicit in the ground or at the ground level. Whenever we go to public spaces, and in the so-called, my lord, the secular laws which I'm mentioning, which also will have to be read in accord with the declaration, if your lordship so grant the declaration. In other words, I will propose at the end, but I will just preface. My lord, wherever husband and wife is used, make it gender neutral by using spouse. Wherever, my lord, man and woman is used, make it gender specific, gender neutral by saying, my lord, person. And I will give your lordship examples in the Special Marriage Act itself. So kindly, my lord, note this. Husband and wife should be used as spouse, and man and woman should be used as person. A large part of this, my lord, will solve our projected interpretation, my lord, of the Special Marriage Act. And what is good here must also apply across, my lord, the spectrum, at least of the acts, my lord, the examples of which I'm talking about. So that's why I said, my lord, 469 will fully apply by removing legislation into a mindset which is evident even today. Then, my lord, the lordship terms 471. 471 talked about reputable and disreputable sex. Kindly see, my lord, the last line of that page. If one accepts the proposition that public places are heteronormative and the same-sex sexual acts partially closeted, relegating homosexual acts into the private sphere would in effect reiterate the ambient heterosexism of the public space. Which means, my lord, in other words, the rule of majority in public spaces. It must be acknowledged that members belonging to sexual minorities are often subjected to harassment in public spaces. The right to sexual privacy, founded on the right of autonomy of a free individual, must capture the right of persons of the community to navigate public places on their own terms, free from state interference. What I'm really requesting, my lord, for a declaration of marriage is really a paraphrasing of this. When I walk into a public space, I walk into the public space with my partner, knowing that the law in the state recognizes this union as a marriage. Nobody will raise a finger of stigma against me. I walk into this public space. I walk into, my lord, public employment. I walk into private employment. I walk in, my lord, for pensions, gratuities, etc. That I am equal to the heterosexual group. And it's not that the heterosexual groups, my lord, wishes or desires or their orientation is one which is correct, and all others, my lord, are incorrect in the same phrase as reputable and disreputable in 471. So this started with, my lord, the negative part, that you won't do this. I am saying let there be a positive affirmation of the fact that since we are equal, created by judgments of this court from Putto Swami downwards, from Nalsa downwards, if we are equal, my lord, require an affirmative, my lord, nod from the court that you are equal, marriage will be equal, walking into public spaces, public employment, private employment will be equal. There will be no stigma. You will not be treated as lesser mortals, as was being suggested yesterday by one of them. And therefore, there will be full enjoyment of the right to life, dignified privacy in my own house, in public spaces, in public employments. That is what, my lord, that is the adversity which we are facing today. I'm only trying to paraphrase the adversity which we are facing today. You go to a school, you write, my lord, parents, names, passports. All those things, my lord, create issues. All those things create issues. Because that's how, my lord, the concept has been. But concepts have evolved. We are not in the same position. I don't blame the 54 Act. My lord, when it was framed, that's how it was. But from 54 till today, my lord, we are 75 years down.
Rodgi, see what Brother Bhatt said. There will be moments, there will be incremental.
Yes, I agree.
They will take time. One fine day, everything cannot change. That must be kept in mind.
I know, but my lord, some amount
But
of real.
once, if you succeed and the status of a marriage is recognized, and if somebody doesn't follow that status of the marriage in another thing, then it's a, I would say it's a violation of the order of the Supreme Court, if we agree with you.
Yes.
If that is the position, then certain other changes will take some
I have no
more
doubt.
steps,
But
more time.
Milord, I entirely agree. I entirely agree. But it should not be, I am at the absolute threshold. I am saying it should not be only, Milord, with that declaration that I go away. I should get some real benefit, don't call it benefit, some real filtering down
If you,
of the effect of the order of this court.
if you succeed and it is held that under the Special Marriage Act,
Yeah.
this is a marriage which can be registered, that itself the registration is what you get.
I appreciate, but Lord, in several acts, I mean, what I'm trying to say is, Milan, it's like saying that consequential effect will follow.
It will,
Something like that, Milord. If I may show, Milord, I have tried to frame, give copies.
there may be,
I have tried to frame in my own words.
you are saying that the consequences of registration of the marriage
The other side.
in different scenarios will arise.
Yes, yes, yes.
Arise.
But just kindly see, Milord, I have tried to frame it, subject to your Lordship's pleasure. If I succeed, then I may get something like this. Are entitled to marry under the Special Marriage Act, regardless of their gender identity and sexual orientation. This is the main declaration. The court may be pleased to direct that the marriage will be solemnized under the provisions of the Act. This is an adjunct of item 1. The words
So the first three.
yes, yes. But Milord, I am more interested in 4. Have a look at 4.
I said 4 is a consequence of us.
Yeah, Milord, 1, 2, and 3 are really, Milord, paraphrasing the same thing. See 4. This I respectfully submit, Milord, subject to your Lordship's pleasure. The court may be pleased to direct that all laws where rights, duties, obligations, and privileges flowing from marriage are conferred to a heterosexual couple married under the, sorry,
Yeah.
Same thing. But you are saying that you want a specific
explicit,
declaration. So
explicit, Milord.
according to you, the area of litigation should not be so wide that it creates a problem.
My Lord.
And though you're confining to the special marriage,
Yes,
you are saying whatever the
yes,
consequences of registration
yes, yes.
must be available
I
elsewhere.
am very grateful. Milord, we spend a lot of time in very carefully drafting,
Right.
Milord, within the contours. Because it should be explicit, Milord. Otherwise, every time, Milord, you start somewhere, you come up to the Supreme Court, 5, 7 years go by, our lives are in any case passing by, Milord, it becomes very difficult. I am not saying, Milord, that this struggle will end today. It can't end. But if we succeed, we should get an explicit declaration in terms of 4 or as modulated by your Lordship, Milord, which flows from 1. Then, Milord,
Mr. Rothi, perhaps you may want to look at para 478 and 482.
yes, I was going to. Milord, I also wanted to read 472.
470.
It's very important. Very important because of the heading. Milord, see, deconstructing the heteronormative framework. I am again and again, Milord, hitting this part because we are being buried under the pressure of the majority. Wherever we go, wherever we stand, wherever we apply, I am buried under that, Milord. Oh, look, this is abnormal. What is normal is what is majority. But that is not the law, Milord. That's a mindset. That is not the law, but that's a mindset which is troubling us, Milord, in our daily lives. This is only an example to say public space is that. But that's what is troubling us, Milord. Therefore, Milord, the importance is deconstructing the heteronormative framework. This is what I am driving at. In the absence of a protected zone of privacy, individuals are forced to conform to societal stereotypes. Puttu Swami has characterized the right to privacy as a shield against forced homogeneity and as an essential attribute to achieve personhood. So I have that shield. That shield must be made explicit that I will not, Milord, be traumatized or stigmatized only because I don't conform to the heteronormative majority. Then, my lord, after the quotation of Puttaswamy towards placetam F, this court has recognized the right of an individual to break free from the demands of society and the need to foster a plural and an inclusive culture. The judgment of 4 judges in Puttaswamy said this. Kindly leave this, my lord. Kindly come to 474 for a few words. The right to privacy enables an individual to exercise his or her autonomy away from the glare of societal expectation. The realization of human personality is dependent on the autonomy of an individual. In a liberal democracy, the recognition of the individual as an autonomous person is an acknowledgement of the state's respect for the capacity of the individual to make independent choices. The right to privacy must be construed to signify that not only are certain acts no longer immoral, but there also exists an affirmative moral right to do them. I rely a lot on this part because the immoral part is now gone. So the negative and the positive. That's how we have our constitution also have affirmative Milad roles. Then Milad, there's a quotation by Richards. Your Lordship may then turn 478 Milad and 479. An individual's sexuality cannot be put in boxes or compartmentalized. It should rather be viewed as fluid, granting the individual the freedom to ascertain his or her own desire and proclivities. The self-determination of sexual orientation is the exercise of autonomy. Accepting the role of human sexuality as an independent force in the development of personhood, acknowledgement of crucial role of sexual autonomy in the idea of free individual. Such an interpretive of autonomy has implications for widening applications of human rights to sexuality. Sexuality cannot be construed as something the state has the prerogative. Because this is important. Let me read this slide again. Sexuality cannot be construed as something that the state has the prerogative to legitimize only in the form of rigid marital procreational sex. This is exactly, my lord, the argument of the other side. Biological man, biological woman, their union is marriage. Marriage will lead to procreation. That is the order of nature and nothing more. That is exactly the argument even today. That's why I say, my lord, in some ways we are revisiting it. Because apart from criminalization, I still face, my lord, these problems. Sexuality must be construed as a fundamental experience through which individuals define the meaning of their lives. Human sexuality cannot be defined narrowly in terms of function as a means to procreation. So, my lord, not the narrow or a pedantic view. To confine it to closed categories will result in denuding human liberty of its full content and a constitutional right. The Constitution protects the fluidities of sexual experience. It leaves to consenting adults to find fulfillment in the relations, diversity of culture, among plural ways of life, infinite shades of love and longing. By criminalizing consensual acts who wish to exercise their right, state is denying its citizen the right to intimacy. The right to intimacy emanates from the prerogative to engage in sexual rights, etc. Then, my lord, Shakti Vahini. That's important. My lord, I will not read Shakti Vahini because Shakti Vahini is quoted here. But my lord may note, my lord, on the side, there are 3 judgments. Shakti Vahini, Shafin Jahan, Lakshmi, and Deepika. I'll repeat, my lord. Shakti Vahini, Shafin Jahan, Lakshmi, and Deepika. These are 4 judgments which lay down and reiterate one principle, that every person is entitled to marry a person of his or her own choice. If it applies, Lord, to the heterosexual group or majority, I respectfully submit it will apply equally, my lord. To us, we may be a minuscule minority, but having the same rights are entitled to the same declaration granted, my lord, by this court in these 4 cases. Then, my lord, 480. In Shakti Vahini, a 3-judge bench of this court issued a directive to prevent honor killings at the behest of Khap Panchayat and protect persons who entered into marriage that did not have approval of Panchayat. So panchayat can be panchayat, community, whatever you call it, my lord. The court recognized the right to choose a life partner as a fundamental right. The learned Chief Justice held. When two adults consensually choose each other as life partners, it is a manifestation of the choice which is recognized in Article 1921. Such a right has a sanction of constitutional law. Once it is recognized, the right needs to be protected, cannot succumb to the conception of class honor or group. Then, Milord 481, Shafin Jahan. Shafin Jahan, this court set aside a Kerala High Court judgment which annulled the marriage of a 24-year-old woman with a man of her choice in a habeas corpus instituted by the father. The court upheld the right to choose a life partner. The Chief Justice held expression of choice in accord with law is an acceptance of individual identity, curtailment of that expression and ultimate action emanating therefrom, or the conceptual structural of obeisance to society will destroy individualistic entity. The social values and morals have their space and are not above constitutionally guaranteed. One of us, Chandrachud J, recognize the right to choose a partner, the important facet. The choice of a partner, whether within or outside marriage, lies within the exclusive domain of individual. Intimacies of marriage lie within a core zone of privacy which is inviolable. I want to repeat this line. Intimacies of marriage lie within a core zone of privacy which is inviolable. The absolute right of the individual to lose a life partner is not in the least affected by matters of faith. Social approval for intimate personal decisions is not the basis. So, majority is not the basis. It is my right. If it is the right, my lord, of the heterosexual group, I would respectfully submit. It is jolly well, my lord, our right, because we are, my lord, equal human beings entitled to the benefits of the Constitution in the same manner as anybody else. Then, my lord, the judgment in Shafin Jahan delineated a space where an individual enjoys the autonomy of making intimate personal decisions. The strength of the Constitution, therefore, lies in the guarantee which it affords that each individual will have a protected entitlement in determining a partner, choice of partner, share intimacy within or outside marriage. We are talking, my lord, of within today. Outside, my lord, in any case is available. In furtherance of the Rawlsian notion of self-respect, your lordship may see, my lord, last 4 lines of this para, just above platism G. This institutionalized expression to love must be considered as an important element in the full actualization of the ideal of self-respect. Social institutions must be arranged in such a manner that individuals have the freedom to enter into relations untrammeled by the binary of sex and gender and receive requisite institutional recognition to perfect their relations. Therefore, my lord, when I say I request for a declaration that we are married, we have to be married under this act, and the state will recognize and register. That, my lord, will be requisite institutional recognition, which will, my lord, follow from the court's declaration of the law under Article 141 and include, my lord, their acceptance, which will be followed by the acceptance of society. My lord, society accepts what the law is. Sometimes the law takes a lead, and I gave your lordship the example of Hindu widows' right to remarry act, which came in the 1800s. There's law acted with alacrity. The society was not ready. It's not ready, my lord, even till early 1900s. Widows remarriage. There, the law acted with alacrity. Here, we need, my lord, to push the society. Push the society to acknowledge us as equals in all respects, because the Constitution says so. And the moral authority of this court, it is not only legal authority, my lord. This court enjoys moral authority. It enjoys public confidence. Judgments of the court and the wisdom and the prestige of the court depends on public confidence. The public has confidence in the court. It's not a case where the public has no confidence, but they are bound to follow only because, my lord, there is a decree of the court. The decrees will be violated by people if people don't have confidence. So, my lord, we rely on the prestige and the moral authority of this court, apart from Article 141. That when the highest court of the land has said that there will be no 377, that you will have a right to marry, that there will be no discrimination in public places. It is that, with great respect, my lord, whether Parliament follows it up with the law or doesn't follow it up with the law, that is what will drive the society in times to come, 2 years or 5 years, whatever it be, to accept this group as a fully homogeneous group with their differences and diversities within one whole. As Justice Bhatt used the phrase, not one whole. That's how, my lord, that's what we are looking at.
They want us to settle.
My lord, my friend is right in saying, our parents have by and large accepted us. We are outside the closet. So we have gone through the process with our parents already, who belong to an earlier generation, to whom it was not the norm as we understand, because the closet was not opened 50 years ago. They have accepted.
To settle.
They want them to settle. They want them to have a family. They want them to have the same recognition, my lord. They don't want them to be ostracized. That the children are ostracized and the parents are ostracized. Oh, you have children who are not normal. So the ostracism will reach there also. It may reach their close friends. All that, my lord, has to be wiped out if the constitutional goal of the preamble, as reiterated by this court in Nalsa, Puttuswamy and Navtej, my lord, have to be given full effect.
These petitioners, their parents.
My lord, in my case, the first case, the ceremony was conducted by the parents, my lord, 10 years ago. So they also, my lord, went through some kind of transformation or whatever you may call it.
By more people.
Yes.
Yes,
And they had a reception in their
they had a reception.
in their hometown.
They had a reception. Some people, my lord, I have read, because you can't get married here, they go abroad and get married, get a certificate from there. So there are all kinds of, my lord, situations.
Small town, 30
Yes, this was a small hometown. Yes.
30.
Then, my lord, now, my lord, something very important. Kindly turn, my lord, to para 553. There is, my lord, in Justice Chandrachud's opinion, a huge discussion of foreign cases, but para 553 is, my lord, US versus Windsor relating to DOMA, which I had given in that chart. So that description is here, my lord. It's important to read that.
Because Nepal, recently 2 weeks ago, another judge from Nepal has come with translation by tomorrow.
Only one more thing, my lord. Mr. Kirpal tells me just above 551, there is a reference to Nepal, my lord.
Yes.
There is a reference to Nepal just above para 551.
What is that? Sunil, Sunil.
Yes.
Sunil Babu Pant.
Just above para 551.
550.
550.
Lord, we'll get this translation tomorrow. A judgment was.
This is a court. Fine. After this, another.
After this, Lord, another thing has come yesterday
2 weeks ago.
or 2 weeks ago. We are going to translate it and, Lord, try and give it to you.
Supreme Court.
Yes, ma'am. Yes.
Which para? 5?
50.
I was reading, Lord, 2 lines above 551. In concluding, the court directed the Nepalese government to enact new legislation or amend existing legislation to ensure that persons of all sexual orientations and identities could enjoy equal rights. So now there is a fresh judgment reiterating this position, and we will translate and give it to Lordships tomorrow or day after. So it's not a case of urban elitism. Say from Nepal, certainly not urban elite. Now say 553. In 2013, in the US versus Windsor, the US Supreme Court considered the constitutionality of Defense of Marriage Act DOMA which states that for the purpose of federal law, the word marriage and spouse refer to legal unions between a man and a woman. Windsor, who had inherited the estate of her same-sex partner, was barred from claiming federal estate tax exemption for surviving spouse since their marriage was not recognized. Kennedy J., writing for the majority, held that restricting the federal interpretation of marriage and spouse to apply only to opposite sex unions was unconstitutional under the due process of the Fifth Amendment. In the DOMA, it's DOMA's unusual deviation from the tradition of recognizing and accepting state definitions of marriage operate to deprive same-sex couples of the benefit and responsibility that come with federal recognition. It is exactly what I seek, my lord. I respectfully submit, my lord, it is exactly what I seek from your lordship. This is strong evidence of a law having purpose and effect of disapproval of a class recognized and protected by state. Domas about purpose and practical effect are to impose a disadvantage, a separate status, so a stigma upon all who enter into same-sex marriage made lawful by the unquestioned authority of the states. So the laws of the states of the US was at variance with DOMA. That you also find in my chart also. Then 554 below. Obergefell. 2 years later in Obergefell, while analyzing precedent of decisions US courts recognizing same-sex marriage, Kennedy J. observed, a first premise of the court's relevant precedent is that the right to personal choice regarding marriage is inherent in the concept of individual autonomy, like choices concerning contraception, family relationship, procreation, child rearing, all of which are protected by the Constitution. Decisions concerning marriage are among the most intimate that an individual can make. Kennedy J. expressed the need to go beyond the narrow holding in Lawrence, this is that Lawrence, Texas case, towards a more expansive view in Obergefell. Lawrence invalidated laws that made same-sex intimacy a criminal act. But while Lawrence confirmed a dimension of freedom that allows individuals to engage in intimate association without criminal act, it does not follow that freedom stops there. Outlaw to outcast may be a step forward, but does not achieve the full promise of liberty. This is exactly, my lord, history repeating itself here. Your lordships have, my lord, annulled 377 as it was annulled in the case of Lawrence. But it can't stop there. It has to go forward. It has to go forward, my lord, with a declaration that we are entitled to the same rights of marriage as anybody else, so that we can walk, my lord, in public spaces. Now, my lord, yes. Now, then, my lord, next passage is very important. By a 5:4 majority, the Supreme Court ruled that the fundamental right to marry is guaranteed to the same-sex couple by the due process and the Equal Protection Clause of the 14th Amendment. Commenting on the right to marriage, Kennedy J. noted, "Not this definition is classic. No union is more profound than marriage, for it embodies the highest ideals of love, fidelity, devotion, sacrifice, and family. It would misunderstand these men and women to say they disrespect the idea of marriage. They are pleased that they do respect it so deeply that they seek to find its fulfillment for themselves. Their hope is not to be condemned to live in loneliness, excluded from one's civilization's oldest institutions, namely marriage, my lord. They ask for equal dignities in the eyes of the law. The Constitution grants them that right."
From your own mouth, like for you, no relationship has been known.
So, my lord, if this is good for society as a whole, it has to be good for us. It has to be good for us. And there is no reason that we should not be included in the whole. We should not be included in the whole or the wholesome, my lord, group of society. My lord, now, my lord, the principles at para 561, that is, my lord, the crux. The principles, and then one or two more passages, and we are done with this. Kindly turn to para 561, my lord. 2 pages down. From an analysis of comparative jurisprudence from across the world, the following principles emerge. Sexual orientation is intrinsic element of liberty, dignity, privacy, individual autonomy, and equality. Intimacy between consenting adults is beyond the legitimate interest of the state. Then, my lord, point 5. Point 4.
When to read all that?
Yeah, I'll read all of them. Yes, I'm grateful. 561.2. Intimacy between consenting adults of the same sex is beyond the legitimate interest of the state. Sodomy laws violate equality by targeting a section of the population for their sexual orientation. Such a law perpetrates stereotype, lends authority of the state to societal stereotypes, and has a chilling effect on the exercise of freedom. The right to love and to a partner to find fulfillment in a same-sex relation is essential to a society which believes in freedom under a constitutional order based on rights. Sexual orientation implicates negative and positive obligations on the state, not only requires the state not to discriminate, but calls for the state to recognize rights which bring true fulfillment. This is the affirmative part, my lord. The earlier part was the negative part, or the negative injunction. The constitutional principles which have led to decriminalization must continuously engage in a rights discourse to ensure that the same-sex relationship find true fulfillment in every facet of life. My lord, I pause here for a minute. This is what I am driving at. I require beyond the badge. I require this, my lord, I respectfully submit. Beyond the badge that I am married. Every facet of life where we face pitfalls when we go outside, my lord, the courtroom and deal with, my lord, like ordinary mortals. This is what we, my lord, face. The law cannot discriminate against same-sex relationship. It must also take positive steps. This is the affirmative part. The state should rather, my lord, come forward and say, all right, we accept gracefully, not grudgingly. My lord, the solicitor referred to the affidavit filed in Navtej. We were in Navtej. The affidavit said we leave it to the court. But the court commented on it in Navtej that we wish that you should have taken a stand in just leaving it on our shoulders. So it's not a matter of grace that the court said there, oh, we leave it to you. That's what the comment is in Navtej, Milad. Now, Milad, 564. This evolution has enabled societies governed by liberal constitutional values such as liberty, dignity, and privacy, equality, and individual autonomy to move beyond decriminalization of offenses involving consensual same-sex relationships. Decriminalization is, of course, necessary to bury the ghost of morality, which flourished in a radically different age and time. I submit, my lord, history is repeating itself. This was only 5 years ago. But decriminalization is a first step. Please mark this, my lord. Kindly read, my lord, the conclusions with this. If this is the first step, the affirmative steps remain. And I submit, my lord, that the prayers that I respectfully seek from your lordships are affirmative steps which will help me lead a dignified life like any other person. Then, my lord, then your lordship may see only one more.
So the last 4 lines of the
Yes, my lord, I'll read.
Constitution principle, yeah.
Yeah. Sorry, my lord, I should have read
51.7.
I should have read
564. 564.
What was they reading? After the first step, the constitutional principles on which it is based have application to a broader range of entitlements. The Indian constitution is based on the abiding faith in the constitutional values. In the march of civilizations across spectrum of compassionate global order, India cannot be left behind. My lord, we have to at least go hand in hand with Nepal. Let's forget anything else. My lord, we are in this region. Let's not talk about the America. My lord, in the US also, a large part of the society is very conservative. Large part. That's why, my lord, you had this DOMA and this, that. And the fact that now in the recent past, they have gone back, my lord, on abortions. They have gone back on abortions. It's not as if that, my lord, being a industrialized country, they are very much ahead. The entire South, the rednecks as they call themselves, they are conservative.
After Oberge fell, they have
So after Oberge fell, it has been accepted and they passed an act now. I mentioned that.
opinion changes.
So things change When the moral authority of an institution says that this is how, please, you look through this prism of gender neutrality, do not look through the prism. My lord, sorry to go back. This Victorian morality issue, my lord, came in 1800s when, my lord, Mr. Macaulay framed this law. You go back to Indian text for hundreds of years, my lord, you go to Khajuraho, go to other places. You see, my lord, these acts are depicted on the walls for thousands of years. That remained, my lord, the concept of morality. It was not, my lord, this Victorian morality which was in India for 1000 years. Our morality was very, very different, far more advanced, not Victorian, not stereotyped, not stigmatized in this form, not, my lord, this formal thing. You can go to so many places and see. But when, my lord, it changed, we have had a succession from, my lord, Lodi dynasty. Lodi Gardens, my lord, dynasty, 1000 years old. Then came, my lord, the Mughal dynasty in the 1500s when Babur came. Then came the British. They occupied India. They imposed, my lord, their code and their moralities. So the society has traveled, my lord, through, I mean, my lord, twisting, if I may say so, twisting sands of time. What we were thousands of years ago, what we were, my lord, in the Mughal period, what we were, my lord, in the British period. And that British period stuck because they made the laws. They conquered India. India became one, my lord, dominion, like Africa, like many other dominions. We became a dominion, and those laws were imposed on us. Those Victorian morals were imposed. I am not on a debate, my lord, what is right, what is wrong. But that is how the shifting sands of time have, my lord, gone over thousands of years. That's why these words are important. That in the march, my lord, in this march, India can't be left behind. And more so, my lord, at least we don't have a debate like England. They don't have, my lord, a written constitution. So it's a matter of debate what the conventions are or what they are not. We have a written constitution like the US. Our constitution is very, very clear. And this, my lord, golden thread, if I may use again, my lord, the preamble 14, 15, 16, 19, and 21, is now cast in stone by several judgments of this court on secularism, pluralism, constitutional morality, no right, my lord, of the heterogeneous majority to steamroll the minority. And in the recent past, we start from Nalsa. I can go back, my lord, to a large number of judgments. But then that debate, my lord, will unnecessarily go on. We don't need that because there is no discordant note. Wherever there was a discordant note, my lord, your lordships have corrected. MP Sharma had a discordant note. And MP Sharma is of the 50s and 60s, my lord. Your lordships have corrected. My lord, the Chief Justice, my lord, also corrected. ADM Jabalpur. So discordant note. One discordant note, MP Sharma, another discordant note. They have been corrected by this court. So, my lord, this court has proceeded in the last 70 years, by and large, on one track, upholding the values of the Constitution, talking about constitutional morality, talking about the fact that if one man, my lord, is discriminated, he can come to the Supreme Court, notwithstanding that, my lord, hundreds and crores stand one way. One man has the right to come to this court and he need not wait for Parliament. Because this court is the guarantor, my lord, and the protector of fundamental rights. The lordships have said repeatedly. Repeatedly. I mean, you don't need to cite cases on that. So if that is, my lord, the position, and India has to go forward, this court takes the lead with its moral authority and legal authority in providing a declaration saying that this is the next step after 377. Look, Mr. Society, this is the norm. Follow this norm. Remove the dogma. Remove the stigma. That is why, my lord, your lordship said, give wide publicity. That's not normally, your lordship don't say that normally. The reason is you are dealing, my lord, with something which is a little out of the normal. It's not, my lord, a case of property or, my lord, money going here or something. It's not one of those cases. It's a very different case. So the obligations, my lord, rest heavily on this court because of its moral authority and the public confidence in the court, more than, my lord, the legal part. Now, my lord, para 600 is very important. Kindly turn to para 600 and 601. And then, my lord, 2-3 more paras, then we are done with this. And the last para of Justice Indu Malhotra, which I will read, my lord, that we owe an apology, etc. But, my lord, para 600. Constitutional morality requires in a democracy the assurance of certain minimum rights which are essential for free existence to every member of society. The preamble to the Constitution recognizes these rights and liberty of thought, expression, belief, faith, and worship, and equality of status, of opportunity. Constitutional morality is the guarantee which seeks that all inequality is eliminated from social structure, and each individual is assured of the means for reference to the rights guaranteed. Constitutional morality leans towards making Indian democracy vibrant by infusing a system of brotherhood. That is, your lordships are now talking about fraternity. This brotherhood takes you back to the principle and phrase fraternity, my lord, in the preamble. Brotherhood comes from fraternity. There is no other phrase of brotherhood in the Constitution. Your lordship may only note, fraternity comes, my lord. Fraternity and brotherhood is the meaning of one or the other and is relatable to the Constitution. Class, race, or brotherhood among a heterogeneous population, belonging to different classes, races, religion, culture, caste, and section. Constitutional morality cannot, however, be nurtured unless as recognized by the preamble. So, my lord, emphasis on the preamble, which became a part, my lord, was declared as a part of the Constitution. There exists fraternity which assures and maintains the dignity of each Indian. Then, my lord, Dr. Ambedkar's decision fraternity. Kindly turn to 601. And as I said, my lord, when the Hindu Code came in 1950, Parliament was not ready. The Hindu Code, my lord, was not only Hindu Marriage Act. It had adoption, success, so many things, my lord. So, my lord, it's not accepted. And Dr. Ambedkar had to resign. Then it came, my lord, in a truncated form. First, my lord, this Hindu Marriage Act, then Succession Act, and the adoption, guardianship, all that, my lord, came separately, not as a part of the Hindu Code bill. So the import is, what was not accepted in 1950 was accepted by Parliament in 56, 58, etc. when it went on. And then became the norm of society. Because nobody says today that there is some error in the Hindu Marriage Act. Prior to, my lord, the Hindu Marriage Act, one could marry, my lord, 3 times. A Hindu could marry, have 3 wives. That became, my lord, an anathema when India progressed to the Hindu Marriage Act. That was the law prevailing from the times of the Mughals, the British. So we brought in a new social order. Sorry.
This is the double-edged sword. Because then the argument of the other side is let the parliament do it.
It's all right, but
Society changes.
point is, Milad. Sometimes, as I said, Milad, the law takes the lead. Sometimes society takes the lead.
Mr. Rotigi, your broad argument there would be that we are talking of constitutional morality. When
My
somebody performs it, that is also constitutional.
That's right. I'm grateful. And Milad, the simple answer is this, to this query being raised again and again. The power, jurisdiction, obligation, and responsibility of this court, Milad, which is cast on this court under the Constitution, is only cast on this court. Even the High Court doesn't have that power. Only this court, as the final protector of fundamental rights and the final arbiter of what the law is and what the Constitution is. 32 is itself a fundamental right. If, my lord, I have a right, and that right is not being, my lord, given its full play, is being clouded or shrouded in some form by the majority, and if I may say so, by the state accepting the majority as correct, I have a right to come to this court, and this court will fail in its duty under the constitution, if, my lord, it does not remedy my right, say, no, I can't do anything, you wait for parliament. My lord, there can't be a mandamus to parliament. I have no voice in parliament. I have a voice to come to, my lord, open the doors of this court and come here and plead before your lordships. None of us have a right to go anywhere else. Except to, oh, you are a representative in parliament, you go to your MLA, you tell your MLA, MLA will go there. That's not an answer, my lord, to the constitution.
The constitutional touchstone only.
I am grateful. That's, my lord, where it stands. And, my lord, this argument has been raised in other cases also. Oh, only 10 or 20 people are affected. Thousands have accepted. Take, my lord, some resolution or some decision of a government. Your lordships have always, my lord, struck down the argument. If one man is affected, he has a right to say that he is affected. If his grievance is valid, then the court will act on it. And that this 100, 200 business was one of the foundations, my lord, in Kaushal. Your lordship may note that. That judgment, my lord, which overruled Nas of this court, which was overruled in Avtej and Puttaswamy, that judgment said, oh, you are a small minority, you are piffling minority,
Minuscule, man.
and 200 prosecutions, what's a big deal? In a country of 100 crore, is minuscule. So, my lord, something like de minimis. Your lordships have a principle of de minimis. If it is so, my lord, inconsequential, the court may not act.
Yeah.
That judgment was founded, my lord, on de minimis. The point is, if one man's fundamental right, my lord, is affected, he has a right to come. And that judgment, therefore, was completely wrong in applying a principle of de minimis on the violation of a fundamental right. My lord, in Shafin Jahan, there is a passage, Lordship Justice Chandrachud, reminding the High Court that you cannot, my lord, go with just, my lord, this majority. I said, my lord, I'll show that. No, all right. Let me read Ambedkar. Mr. Kirpal wants me to read. My lord,
Always good to read.
my lord, para 600 at the bottom of that page.
Yes.
Man who faced discrimination
Yeah.
himself.
Yes, of course. My lord, your lordships are aware in London, wherever, my lord, famous people have lived, their names are, my lord, in a blue plaque on a building that here lived, say, X or Y. And one of those houses is where Dr. Ambedkar lived, with that blue plaque. They give the period where so and so lived, whether it's a Churchill or whoever it was. That's what Ambedkar. An ideal society should be mobile, should be full of channels for conveying a change taking place in one part to the other parts. In an ideal society, there should be many interests consciously communicated and shared. There should be varied and free points of contact with other modes of association. In other words, there must be social endomosis. What does that mean? Endo-osmosis. This is the fraternity, which is also another name for democracy. In his address, last address to the Constitutional Assembly, he defined the fraternity as a sense of common brotherhood of all Indians. As in the social and economic plane, Indian society was based on graded inequality. Dr. Ambedkar had warned in clear terms, without fraternity, liberty, and equality cannot become, equality cannot, and therefore is this, that way, cannot become a natural course of things. It would require a constable to enforce them. Without fraternity, equality, and liberty, there will be no deeper than coats of paint. Constitutional morality requires that all citizens need to have a closer look at and understand and imbibe the broad values of the Constitution, which are based on liberty, equality, and freedom. Constitutional morality is thus the guiding spirit to achieve transformation, which above all the Constitution seeks to achieve. The acknowledgement carries a necessary implication. The process through which a society matures and imbibes constitutional morality is gradual, perhaps interminably so. Hence, constitutional courts are entrusted with the duty to act as external facilitators. Very important phrase, my lord. To act as an external facilitators and to be a vigilant safeguard against excesses of state power and democratic concentration of power. This court, being the highest constitutional court, has the responsibility to monitor the preservation of constitutional morality as an instrument of fostering conditions for human dignity and liberty to flourish. Popular public morality cannot affect the decisions of this court. I would like to add also, my lord, cannot defer the decisions of this court for the legislative process. Then we'll add 604 on the next page. Invocation of constitutional morality must be seen as an extension of Dr. Ambedkar's formulation of social reform and constitutional transformation, highlighting the significance of individual rights and social terms. He observed, the assertion by the individual of his own opinion and beliefs, his own independent interest is over and against group standards, group authorities and group interests in the beginning of all reform. So, my lord, reform is also a continuous process. Society has gone through a large number of reforms, from widows, from child marriages, from this, that, and the other. Now, my lord, 606. Constitutional morality will impact upon any law which deprives the LGBT individuals of their entitlement to a full and equal citizenship. It's again a reiteration of what I respectfully seek from this court. Nobody can deny, my lord, a full and equal citizenship will be sans marriage, will be sans a family, will be sans the respect of a marriage, and forever to be treated as those two people. After the constitution came into force, no law can be divorced from constitutional morality. Society cannot dictate the expression of social sexuality between consenting. This is a private affair. Constitutional morality will supersede any culture or tradition. The interpretation of a right in matter of decriminalization is beyond the determination, so may be determined by the norms. So, my lord, will supersede any culture or tradition. Reference was made to culture or tradition by the other side yesterday. 608. LGBT living under the threat of conformity, grounded in culture, morality have been denied to a basic human existence. They have been stereotyped and prejudiced. Constitutional morality requires this court not to turn a blind eye to their right to an equal participation in citizenship and equal enjoyment of life. Constitutional morality requires that this court must act as a counter-majoritarian institution which discharges the responsibility of protecting constitutional and entrenched rights regardless of what the majority may believe. Constitutional morality must turn into a habit by citizens. I respectfully submit, my lord, it will become a habit only when it is so declared by an authority no less than the Supreme Court on account, my lord, of its moral authority. By respecting the dignity, this court is only fulfilling the foundational promises of our constitution, which is, my lord, way back in 1950. Today we are in 2023. My lord, 613. 613. Now, my lord, 613 will apply equally to the next step, namely marriage. The choice of a partner, the desire for personal intimacy, and yearning to find love and fulfillment in human relationships have a universal appeal, straddling the age and time. In protecting consensual intimacies, the Constitution adopts a simple principle. The state has no business to intrude in these personal matters, nor can societal notions of a heteronormative regulate constitutional liberties based on sexual orientation. Actually, my lord, most of this applies not only to, my lord, decriminalization, applies to our position today. Maybe it had been argued then, maybe it would have been done then, because this is the basis. I am not invoking any new basis, my lord. The basis is already set. It's already the law of the land. But it stopped at decriminalization because that was the issue then. But, my lord, Nalsa, Puttu Swami, and this, and the basis and the groundwork cemented by this court is the groundwork for the declaration which I seek, my lord. I seek no more. I don't seek any extension. It is already here. Everything is here. See 615, my lord. Second line. In addressing the LGBT rights, the Constitution speaks as well to the rest of society. In recognizing the rights of LGBT, the Constitution asserts itself as a text for governance about the dominance of sex, which promotes true equality, does so by questioning prevailing notions about the dominant of sexes and gender in its transformational role, the Constitution directs our attention to resolve the polarities of sex and binary gender. In dealing with these issues, we confront much that polarize our society. Our ability to survive the free will depend whether constitutional values can prevail over the impulse of the time, that is of the current times. Lord 616. 158 years is too long a period for the LGBT to suffer the indignities of denial that has taken 68 years in after the advent of the Constitution. Is a sobering reminder of the unfinished task which lies ahead. It's also a time to invoke the transformative power of the Constitution. Then we'll add the declarations in 618. See, we'll add 618 too. Now it applies equally here today. It doesn't apply or limited only to decriminalization, my lord. See 6182. Members of the community are entitled as all citizens to the full range of constitutional rights, including liberties. The choice of whom to partner, ability to find fulfillment in intimacy, right not to be subject to risky behavior are intrinsic to constitutional protection. This applies equally to marriage. Not restricted, my lord, only to that no case will be filed against you. Point 4, my lord. Members are entitled to the benefit of equal citizenship. This is the broadest phrase. Without discrimination and to the equal protection. I respectfully submit, my lord, these principles apply with equal force today. After a passage of 5 years, these principles are the same even for what I want. Then only one thing, my lord, I wanted to show. Kindly, my lord, turn to 640. This is Justice Indu Malhotra. 640. Actually, my lord, it is similar. Your lordship may note, I don't want to read it. 640, 641. 640.2.4 may be seen, my lord. So, my lord, it's the same thing in paraphrasing in different words because of a different learned judge. 642.4. Sexual orientation is innate. It is an important attribute of one's personality and identity. Homosexuality and bisexuality are natural variants of homosexuality. LGBT have little or no choice over their orientation. This is very important. So it's not, my lord, an elitist concept that I have acquired something today. It is innate. I have little or no choice. LGBT, like other heterosexuals, are entitled to the privacy and the right to lead a dignified existence without fear of persecution. So it's not prosecution only, it is persecution. They are entitled to complete autonomy over the most intimate decisions relating to personal life, including the choice of partners. So, my lord, it will include a sexual act, it will include companionship, it will include marriage, it will include family, it will include walking in public and other spaces. Then we'll have right to privacy 640.3. 640.3.3, Your Lordship may mark placitum E. The right to privacy is not simply the right to be let alone. It has traveled far beyond that. It now incorporates the idea of spatial privacy, decisional privacy, or privacy of choice, extend to the right of fundamental personal choices, including those relating to sexual conduct. So, we have right to make a fundamental personal choice, not limited to sexual conduct, will include, willy-nilly, will include, my lord, marriage. And then, after life, right to health, my lord, your lordship will have, my lord, 644. I wanted to read that note. 644. History owes an apology to the members of this community and their families. So it's not only community, my lord, I emphasize family, family is also here. For the delay in providing redressal for the ignominy and ostracism that they have suffered through the centuries. The members of this community were compelled to live a life of fear, reprisal, persecution. Account of ignorance of majority would recognize that homosexuality is a complete natural condition, part of a range of human sexuality. The misapplication denies the fundamental right of equality guaranteed by 14. Infringement, it infringed the fundamental right to non-discrimination under Article 14, etc. And that's how the conclusion.
One para. Just one para.
Lord, I have given your lordship those, I don't want to read now, those 4 cases on the right to marriage. I can give my lord the citations. Shakti Vahini is quoted there already. Shafeen Jahan is also quoted there, my lord. The 2 other ones, your lordship may note, my lord, that's all. So there are 4 of them. Shakti Vahini, under the head of right to marry a person of your own choice. Shakti Vahini and Shafeen Jahan are quoted in Justice Chandrachud's opinion. The 2 others, my lord. One is Deepika. Deepika, my lord, is 2022 SCC Online SC 1088, para 26 to be precise. And Lakshmi, my lord, Lakshmi Bai, Mr. Justice Call, speaking for the court, 2021, 3 SCC, 360, paragraph 11, my lord, to be precise. Now that ends, my lord,
Sorry,
the
Mr.
tracing of the law.
Okay, in Deepika saying what para did you specify?
26, my lord.
Para 26. And
Where is the Nepal subsequent judgment?
in Lakshmi Bai.
Of Deepika?
Nepal judgment, subsequent.
Yeah.
Nepal.
Got it now.
Oh, you got it?
I'll get a printout and give it.
My lord, I'll get a printout and give it to your lordship. Headline. The Nepal judgment. My lord, your lordship might.
You have given all this in your compilation.
Yes.
You could just give the page numbers.
Yes.
That's fine.
I'll do that. I'll do
And
that.
the Nepal judgment, you can email separately. You can separately email it to the court master.
We'll give it. That's all.
Email it to the court.
Yeah.
Kiran,
I'll leave
go
that.
ahead.
Now, my lord, we go to the special marriage act. Kindly see, my lord, section 2, B. My lord, as I had mentioned yesterday, section 2, like all other sections in other acts, starts with unless the context otherwise requires. So, there is elasticity as a measure of a legislative tool to alter the definitions if the context requires, my lord, because no act can look at all the situations which may arise. But I am not restricting my case only on this, because I am saying, my lord, this legislative tool may be good when you are discussing a normal law, but today we are discussing a constitutional provision. And if the constitutional declaration is granted, then all subservient law, all laws are subservient to the constitution. They must then be read in conformity with the constitution. It is on that principle that I am going. This unless the context is, my lord, for normal legislative issues. So now, my lord, please see 2B, degrees of prohibited relationship. A man and any of the persons mentioned in part 1 and a woman and any person mentioned in part 2 are within the degrees of prohibited relationship. So let's see, my lord, part 1. A man with a person in part 1 will be prohibited. So kindly turn to part 1 of schedule 1 at the end of the act.
So that's in part 2. What parts will apply?
Now, my lord, see part 1. This is all women. So prohibition is that a man will not have a union with all the persons named in part 1, and similarly, a woman will not have a relationship and will be prohibited from having a relationship with the males mentioned in part 2. Because it's what
versa.
exactly the same thing. Now, technically, Lord, father is missing in part 1. I am just posing a question. So a man cannot have a relationship with all those who are named in part 1 who are women. But technically, it can include a father. I am only saying technically. Similarly, my lord, in part 2, a woman cannot have any relationship with all the males mentioned in part 2, but technically it include a mother. My lord, it's not there. It's just a conundrum, my lord. But my lord, if you read it now, the way I am saying, if you read it the way I am saying, Lord, man and woman as a person. So a person and any person mentioned in part 1 and a person mentioned and any person mentioned in part 2
Will apply now.
so both will apply now.
Both parts.
They'll be both cumulative.
Correct.
Club them.
Correct.
You're saying club them. So what you want to read it as, Mr. Rohtgi, as one understands, is a man, instead of a man, any person or any of the persons mentioned in part 1 and 2 of the said schedule. Simple. This is what you're saying.
So, according to you, if two men are getting married
So
under the special,
consequently, my lord, once it is person, then 1 and 2 will coalesce and become one. But in fact, it is better reading. If it becomes one, part 1 and part 2 will coalesce into one list. And then
so if it's two men getting married, it's not just part 1 which will apply. Likewise, if two women are getting married,
Correct.
it's not just part 2.
My lord,
according to you.
my lord. It just so happens to fit, my lord, when I was doing this, that's how it fits. See, my lord, for example,
But this is also a tacit indication that the Special Marriage Act didn't contemplate people of the opposite sex getting married, actually. Oh, sorry. I meant same sex.
my lord,
Same sex.
with ultimately, my lord,
Yeah.
one can say you're doing violence on the conventional.
It was 1954.
No, one can say you're doing violence by doing all this. But, my lord, if this has to conform to the constitutional declaration, it has to be this. Otherwise, this will become unconstitutional if the declaration is granted. We don't want it to be unconstitutional. We want to utilize it.
Actually, I was telling brother that one of the relation I just saw is sister's daughter.
Yes.
Column 30. But in many communities, in many
Right.
areas, it is almost an intrinsic right to
Right.
There is a proviso.
Custom, yeah.
So therefore, we are such a varied country that
Yes, my lord.
there are
My lordship is right.
differences.
Section 4D proviso, which talks of where it's
Custom.
permissible under custom.
That is saved.
I was only flagging.
That is
even
saved.
these
Justice Bhatt is right, my lord. If your lordship
very
sees.
difficult. I'm saying it's very difficult to put down in hard words where you have such a varied
Yeah.
norms and customs and
Now, my lord, kindly see section 4.
Very fluid.
Conditions relating to solemnization. Now, 4.1 refers to person. So there is no problem. 4.1a also refers to a spouse. B refers to party, no problem. They are gender neutral. Now see C, my lord. C has males and females. You leave it as it is. If two men are getting married, it is 18. If two female or 21. If two females are getting married, it is 18. You don't need to change it. My lord sees, this is only sees, my lord C.
The whole idea is that you go beyond your.
Yes, yes.
Then Again, why?
Why
revert to
male
it
and
then?
female?
See,
Then
then
you are
it
saying
becomes,
person.
you're flitting in and out.
Yes.
Comes to prohibitions, for one, you
Yes.
revert back to your, and then there are problems when it comes to transgender persons.
Yeah. Yes. 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 Now, my lord, for example,
Then you have to read it like that. Person.
Yeah.
So how would you read?
only thing is, sorry.
How would you read, say, if you were to substitute the word male and female? You would say,
Now, so, my lord, one way to read is a person.
yes,
If you read it as a person, then it will give a dual age. What will be 18? What will be 21?
then,
That be the problem. I mean, I don't mind reading it as a person. So it will be a person is completed 21.
No, it can't.
And the person is,
So for the purposes of the main part which you seek a
Yes.
definition of, where it's a person, for the main part,
my lord.
it's a person.
Yes.
Neutral in the sense
Right,
that
neutral.
it is gender neutral. But for C, for purposes of C, you have to, you say we will.
So you retain male and female because there are two ages, my lord.
But then you are addressing only.
but you only addressing male and female.
Increase the minimum.
My lord, there is a proposed bill to increase 18 to 21.
Right.
There is already a bill because they find that 18 is also too low.
Right.
For child, my lord, marriages, 18 is also too low. So they want to make it 21. The moment 18 becomes 21 for women,
That's a slightly dangerous argument. Then.
no, I'm only indicating. My lord, I'm not an argument.
In fact, interestingly, before just Narsma and me, this part that the female shall be the age of 18 years was challenged by Mr. Ashwini Upadhyay.
Yeah.
And we dismissed the petition saying that if we hold that that part is unconstitutional, there'll be no minimum age of marriage for women at all. A 4-year-old girl can then get married. So we said, therefore, look, we'll not.
Your lordship may read it up.
Ashwini came here.
So
Remember?
this is the second. Does it impact, how does it impact those who are a heterosexual couple? Because then you will be looking at this interpretation in a different.
Yes, yes, absolutely right. Because we can't forget the heterosexual group.
That's right.
Because they can also get married. So we can't forget it. So keep that and keep it as it is.
No, then in that case, what you're saying is for sex relationship, this is the person. For heterosexual couples, for heterosexual
Yes.
marriages, part 1 and part 2 apply.
Right.
That is one more.
That is one way. Yes. Yes.
One way. That is.
No, correct, correct. So your lordship is right. Keeping the distinction in mind for the heterosexual and for, my lord, this.
And then there's a third way, which is for a same-sex male couple,
Yeah.
it will be 21. For a
And same-sex female couple will be 18.
would be 18.
Will be 18.
I don't know.
That you deal
Do
with.
it exactly for the transgenders.
Is to make everything as 21 for purposes
Yes,
of.
no problem. We have no problem.
Then if
Now see, my lord, 12.
you go by,
Sorry. One moment, please.
if you go by the act which
Yes.
Sir pointed out
Yes.
yesterday,
Yes.
there are so many other spectrum varieties. How do they get accommodated? When you look at them, how do they get accommodated? Work that out because
My lord, they want to deal with that. Otherwise, my lord, I will cover all the fields.
Section 4 guarantees them, my lord, the option to choose gender they manifest. My lord, a male will manifest as.
so ultimately you're going back to the social stereotype which you want to avoid.
My lord, that is because we are maintaining
No,
equality.
not a question of because.
The minimum is 18, it cannot be 21.
One second, my lord is saying something. My lord is saying.
No, I understand. So ultimately, you say you go back there, but for here it is this, and for normal for heterosexual couples it is whatever they are. So this interpretation has to be threefold for this enactment.
Lord, it syncs with, my lord, section 4 only says that.
It syncs with what you want. It suits your purpose.
No, no, no.
The court has to.
My lord, the act guarantees the manifested gender, my lord. Act guarantees the manifested gender.
All right, we'll
Your lordship may see that.
allow. Yes.
Because the transgender will have to fall in one or the other, my lord, for that purpose.
Anyway, you're breaking
Your
up the
lordship will see that.
submission, so we'll hear Mr.
We'll address
Vishwanathan on that.
Yeah. Now, my lord, see 12, for example. 12, place and form of solemnization. Now, my lord, 12.1 talks about parties. 12.2 talks about parties. Now, look at the oath. The last line. I, A, take thee, B, to be my lawful wife or husband. You replace it with spouse. You replace it with spouse. That's it. I take you as a spouse.
27.
My lord, kindly turn to 27. No, see 22. 22. Restitution. Restitution, my lord, here also it is husband or wife. Read spouse. Because the third line is aggrieved party. And the explanation is person. So they are neutral anyway. 23 is the same position, my lord, for judicial separation. See 27. Here also, my lord, divorce can be by either party, husband or wife. So you have to read spouse. See, my lord, 1 capital A. A wife may also present. So a spouse.
Expanded then.
That's all.
Six into this.
Then, my lord, 36, 37. Now, this is the right, my lord, only to women. 36 and 37. Actually, my lord, apart from anything else, so many years have gone by that this would be otherwise unconstitutional today. To say that only, my lord, a husband will pay to the wife. Today, in maintenance, under the Hindu Marriage Act, it's either way. It's either way, my lord. If the wife is earning much more, the husband is not earning, the wife will pay.
That's right.
This is earlier mindset. Actually speaking, it will be unconstitutional today to say, my lord, only one spouse in the marriage will pay on the premise that the husband is the bread earner and the wife is not. So actually 36 and 37 we suffer from that problem. So read it as spouse, give the right to both, not only here, but there also.
I was just.
So, my lord,